all like what we discussed yesterday regarding on the aviation law when we were discussing regarding the insurance law and the criminal law aspects, which are all integrated, and the fashion in which Mr. Bhatt had yesterday explained to us the career opportunities, the insurance perspectives, the conventions perspectives. I can say that it's a different topic altogether. Yesterday, as we had discussed, that the aviation law and the space law have their own space within space, though, and today we will be talking only on space law, but more specific in the space law, but not the space what we are talking in the normal common parlance. Without taking much time, I would request Mr. Bhatt to unmute himself and can take the things forward. Over to you, sir.
Good evening to all of you. It's always a privilege for me to speak on something which is very close to my heart, space law. I think let me first reiterate what I have told always in different fora, especially with respect to the space law. That is, this law is going to be the law of this particular century itself. I have no hesitation in stating that the space law is going to be the law of this particular century. It is not just because space law is very close to my heart. I am telling that actually this is the law of the century. I am telling primarily because of the reason that there has been tremendous developments which are taking place in both the field of space activities as well as in the field of space law. Maybe sitting in India, wherein actually we are not having too much of the private space activities, we might not be able to appreciate what is the cornerstones of actually the space law, how wide it is, how much of the developments are taking place in this particular field. If you look from the Western perspective, especially maybe from the perspective of the United States or the European states, or even for that matter, Australia, wherein a lot of private space activities are taking place, you can see that there is a lot of scope for not just the academic debate in the field of space law, but also a lot of scope for practice in the field of space law. Please keep in mind, space law is one area wherein the stake which is involved is multi-billion dollars. There is huge investment, and any dispute which arises out of the space law would involve heavy stake, and ultimately actually any lawyer who is practicing in the field of space law would also be able to have good career opportunities. I think yesterday, towards the end of the session on aviation law, there was a question about the career opportunities in the aviation law. Let me tell you that the space law has got much more scope. Only thing is that sitting in India, we might not be able to understand how much of the scope is there in the field of space law. And probably even a small percentage of the stake involved in the space activities, or maybe dispute arising out of the space activities, that would make the career earning for a lawyer. So it's a huge amount. So therefore, there is no scarcity of the opportunity for those who master in the field of the space law. Now, having said this, let me tell you the outline or maybe a brief overview of the entire gamut of the space law. Of course, as I told yesterday also, it is not possible to cover everything in this 1 hour lecture. What I'm going to do is to give you a highlight of what are the different things which are covered within the ambit of the space law. First of all, let me just give you a brief historical background. As all of you must be aware of, 1957, the first space object entered into the outer space, Sputnik 1, the erstwhile Soviet Union satellite. When the Sputnik entered into the outer space in 1957, almost the whole world was astonished with the Soviet achievement. Because until that point of time, the understanding of the world community was that whatever goes up should come down. And it is not possible to breach the Earth's gravitational phenomenon and to enter into the outer space. So precisely because of that reason, the Soviet entry into the outer space was hailed as one of the greatest achievements in the history of the mankind itself. But the United States immediately jumped into the race. In the very next year, it launched Explorer 1. Subsequently, a kind of a space race developed between the USSR and the United States. And we also see that a lot of developments have taken place. Since then, actually, maybe the human entry into the outer space, landing on the moon, and different kind of commercial activities which has come up over the period of time. So a new era, the space age, began after the entry of Sputnik into the outer space. Now, soon after this, there were two questions which cropped up primarily in the international level. First, first of all, what should be the line of demarcation between the airspace and outer space? Or in other words, where the airspace ends and where exactly the outer space begins. This is very crucial because, as I pointed out in yesterday's session, aviation law and space law are the two different sets of law. While the airspace is governed by the principle of sovereignty, outer space is governed by the principle of freedom. Everyone has actually the freedom in outer space. So therefore, the laws governing the airspace and outer space are entirely different. So consequently, we have to first understand where exactly the airspace ends so that we can determine where exactly the outer space law can be made applicable. Unless and until we know the distinction between the airspace and outer space, we will not be able to find out which law is to be made applicable at what altitude above the Earth's surface. So therefore, the first question was with respect to the definition and demarcation of the outer space. Different theories have been developed over the period of time for the purpose of the definition and demarcation. We have theories like gravitational pull theory. We have actually theory of satellite orbit, Kármán line theory, atmosphere theory, biological theory, functional theory. Different theories have been developed over the period of time for the purpose of demarcation of the outer space from the airspace. But unfortunately, none of them has been successful. None of them has been successful to divide the outer space from the airspace, because naturally there is no distinction which is existing between the airspace and outer space. As we move upwards, only thing is that the density of the atmosphere would reduce down and there is no void as such. Even though we say that outer space is void, it is not actually void in practical terms. The density of the atmosphere becomes less and less as we move upwards. So precisely because of that reason, we don't find any natural distinction between the airspace and the outer space. Added to that, one more major difficulty or one more major reason why the demarcation has not become possible is that as the technology has developed over the period of time, there is a kind of a convergence between the airspace and outer space. If I have to tell it in simple terms, airspace is moving upwards and outer space is moving downwards. Of course, not actually in actual terms, but what is happening is that the aviation activities are happening at a higher altitude, and the outer space activities are having at a lower altitude. The lowest orbit is coming down. The highest altitude wherein the aircrafts can fly is moving upwards. So with the development in technology, it might be a possibility that there is a certain zone above the Earth's surface wherein both the aircrafts can fly and also the space objects can orbit around the Earth. So precisely because of that reason, it becomes very difficult to demarcate the outer space from the airspace in terms of altitude, and we will not be able to say that at what height outer space law is applicable until what altitude the airspace aviation law is applicable. So therefore, we have the difficulties, but what international community has done is that at the UN COPUS level, United Nations Committee on the Peaceful Uses of the Outer Space, they have agreed that it has to be decided on case-by-case basis. Which law has to be made applicable? Is it aviation law or is it space law for a particular activity above the Earth's surface? That has to be decided on case-by-case basis by the competent authority by looking into the different factors. So that's how the definition and demarcation is still a moot issue, but the states have agreed that it has to be decided on case-by-case basis. Then the second significant question which cropped up after the entry of Sputnik into the outer space was that what should be the law which should be applicable to the outer space activities? Because the aviation law by then was developing. As I was discussing yesterday, Chicago Convention, Warsaw Convention, all of them have come into existence. Even the Rome Convention, all of them have come into existence by then. But with respect to the outer space activities, there was no separate law which was developed by then. So one of the questions was that what should be the law applicable in outer space? Is this the public international law? Is it the municipal law of a particular state which is carrying on the activity? Or is there a situation that there is no law in the outer space? What should be the law applicable? That was the crucial question which cropped up. What came to the rescue for the purpose of the development of law at that particular point of time had been the United Nations. Especially the United Nations General Assembly started passing series of resolutions with respect to the outer space activities. Starting from 1958 itself, the very next year after the entry of Sputnik into the outer space, the UN General Assembly started passing different resolutions. And more importantly, it has also established an international body in the form of UN COPUS, United Nations Committee on the Peaceful Uses of the Outer Space, which has been instrumental in terms of further developments of the space law at the international level over the period of time. So therefore, the first stage of development of the space law took place in the form of the UN General Assembly resolutions. But unfortunately, UN General Assembly resolutions are not binding on the states unless and until it is stipulated under the UN Charter. They are not binding on the states. They are all soft laws. So therefore, in 1960s, especially in the mid 1960s, there was a lateral thinking in terms of developing binding law, maybe the treaties, primarily the treaties. So this thinking resulted in 5 major treaties being entered between 1967 and 1979. 5 major treaties were entered. 1967 Outer Space Treaty was entered, which provided the fundamental principles or the grand norm with respect to the space activities. 1968 agreement with respect to the rescue of the astronauts and the space objects and the return of the astronauts and the space objects was entered. Rescue and Return Agreement, 1968. 1972, a Convention on Liability for the damage caused by the space activities has been entered. 1975, Registration Convention was entered for the registration of the space object. And finally, in 1979, Moon Agreement was entered. An agreement especially with respect to governing the activities on the moon and other celestial bodies. And in fact, if you look into the Moon Agreement, it has got stronger provisions when compared to that of the Outer Space Treaty. Unfortunately, Moon Agreement on the one hand failed to a greater extent. You can find that even till today, there are only 18 states who have signed and ratified the Moon Agreement. There are only 18 states across the globe, and that too, many of them are not even spacefaring nations. The countries like US, Russia, India, China, Japan, all of them are outside actually the Moon Agreement. Only say Australia is party to the Moon Agreement, and a couple of European states are parties to the Moon Agreement. Apart from that, most others are not even having the space activities. And in Australia or maybe some of the European states also, you don't find the activities on the moon and other celestial bodies. So precisely because of that reason, the practical applicability of the Moon Agreement 1979 itself is debatable. Unfortunately, after 1979, the consensus which was required for the purpose of the treaty making started to obliterate. States were not ready to enter into the separate treaty governing the different aspects of the outer space activities. And as a consequence, the United Nations has to go for a kind of a midway approach. Of course, they cannot actually have the treaties, the hard laws, so therefore they went for something called as a midway approach. Between a hard law and soft law, in practical terms, there is no midway approach. But in one of my articles, I have argued that this third stage of development is somewhat a kind of a midway approach, primarily because of the reason that the states have tried to respect to the set of principles which have come into existence in the third stage of development. After 1979, if you look in the international level, there are 3 set of principles and 1 declaration which have been entered in the third stage of the development, and the states have tried to adhere to these set of principles. That's the reason why I term it as a kind of a midway approach. In this third stage of the development, we can see that first of all, there was actually the principles on direct television broadcasting, 1982. Then we have a principle on remote sensing of the Earth from the outer space, 1986. Then the third set of principle was on the nuclear power sources in the outer space, 1992, NPS in outer space. So they dealt with the issues of direct television broadcasting, remote sensing from the outer space, as well as the nuclear power sources used in the outer space activities. Finally, in 1996, there was a declaration for the purpose of the benefit sharing, but unfortunately, it has also not been very much successful. So a declaration was entered to ensure that the benefit of the space activities should also go to the other countries. It should not confine only to the developed countries. But unfortunately, practically, it has not been implemented by any of the countries in precise terms. So I should say that the development of space law has taken place in 3 stages. First was the soft law, the UN General Assembly resolutions, then the 5 treaties, the hard law, and then 3 set of principles and the 1996 declaration, which is all a kind of a midway approach. But despite all these developments, in the international level, what we are having at present in terms of binding norm are the ones which are developed in 1960s and 1970s. The 5 treaties, 5 space treaties. And these treaties enshrine primarily some 7 major fundamental principles governing the outer space activities. You can find 7 major fundamental principles which govern the outer space activities. And all of them are rooted in the common thread of the common rights principle. If you go through them, they are all actually in a way indicating for the common rights principle. Everyone should have actually certain rights with respect to the carrying on the space activities. Now let me briefly touch upon each of these fundamental principles. First of all, province of all mankind. If you look into Article 1 of the Outer Space Treaty, it declares outer space and celestial bodies and exploration and use of them as the province of all mankind. What do we mean by province of all mankind? We don't find any definition in the space treaties. But generally, it is understood that this is something which belongs to everyone, and there are certain set of scholars who also argue that whenever some state is using this outer space of celestial bodies, whatever benefit they derive out of that, they should go for voluntary sharing. At least the voluntary sharing of the benefit has to be done by the concerned state, whoever is making use of the outer space and celestial bodies. This is based on the logic that when we agree that certain things belongs to everyone, and if some people or individuals are using these resources, ultimately they have to give the due share to others, whoever is also having the stake in these resources or in these properties. It belongs to everyone, so therefore we should respect the rights of others also. Whenever we use, we have to go for sharing the benefit with others. So that is the logic behind the principle of province of all mankind. The second major principle, which you can see under Article 2 of the Outer Space Treaty, has been the principle of national non-appropriation. It says that the outer space, including the moon and other celestial bodies, is not subject to the national appropriation by claim of sovereignty, by use or occupation, or by any other means. These are the exact wordings of Article 2 of the Outer Space Treaty. One of the crucial questions which crops up about Article 2 is that there is a prohibition on national appropriation, but what about an individual appropriation? The states might be prohibited from appropriating the outer space of celestial bodies. What should be the status of individuals? Can an individual appropriate the outer space and celestial bodies? There is some set of scholars, especially the Western scholars, in the wake of more and more commercial space activities, they have started arguing that individual appropriation is not prohibited under Article 2 of the Outer Space Treaty. Only the national appropriation is prohibited. I should say that this is an absurd argument. It's highly illogical, especially because the drafters of the space treaties would not have thought of allowing the private players to appropriate the outer space and celestial bodies without conferring the rights to the states. It's highly illogical to think about that. Added to that, if you look into the system of allocation of property, both in the common law system as well as in the civil law system, we would safely conclude that even the individual appropriation is prohibited within the ambit of the national appropriation under Article 2 of the Outer Space Treaty. This is something which is missed out by many of the scholars. If we look into the common law system of the allocation of property, it happens on the basis of the fact that the states own everything, right? Everything, all the property belongs to the state. And whatever we enjoy as our property is a kind of a grant by the state. It is granted to us by the state. That's why in the common law system, we have the principle of eminent domain. State can take our property for the public purpose at any point of time. Right? So therefore, the notion is that the states own the property and the individuals basically get the right through their states. By applying this logic, definitely a citizen of the common law system cannot claim any property right over the outer space, moon, or any celestial body. Because the respective state themselves cannot actually claim any property rights. They cannot have the sovereignty over the outer space and celestial bodies. Once that is the case, individuals in those states also cannot get any right through the states. So in the common law system, claiming of the property rights or maybe individuals appropriating the outer space and celestial bodies is completely ruled out. If you look into the civil law system, then also we can safely conclude that the individual claims are not permissible. Because in civil law system, the property allocation, even though it operates differently, there is no requirement of state owning the property for the purpose of granting the property rights. But what happens is that an individual can go and occupy a particular property which does not belong to anyone, or in simple terms, the terra nullis, res nullis, which does not belong to anyone. And if they develop that particular property, the concerned state would recognize the right of that individual in the property due to the labor, whatever has been put in for the development of the property. The person may go occupy the property, fence the territory, construct a building, or convert it into the agricultural land. All these developments may be done by a particular individual, and whatever labor which has been put in the development would be recognized for the purpose of granting the property rights in a civil law country. But please keep in mind that all these things can happen only when the property does not belong to anyone. It should be a terra nullis. If it belongs to someone else, people cannot go and occupy that property. And we have already agreed that the outer space and celestial bodies are province of all mankind. In other words, it's a kind of a variant of the res communis regime. It belongs to everyone. So given that factor, even in the civil law country, an individual cannot claim the property rights over the outer space or the celestial bodies. So national non-appropriation would also in turn include a prohibition on the individual appropriation within the ambit of Article 2 of the Outer Space Treaty. Next, the third fundamental principle is with respect to the freedom of exploration, use, and scientific investigation. Again, if we come back to Article 1 of the Outer Space Treaty, it clearly says that every state has got a freedom of exploration, use, and scientific investigation. Please keep in mind, Article 1 provides the freedom only for exploration, use, and scientific investigation, not for exploitation. There is no freedom which has been given for the purpose of exploitation, even though there has been misinterpretations. Some of the scholars have tried to argue that exploitation is also permissible. It is not something spelled out under Article 1. Freedom is confined only to the exploration, use, and scientific investigation. That too subject to other principles, whatever are enshrined under the space treaties. It is not an unbridled freedom. It should be subject to the respecting the rights of other countries as well. So without respecting the rights of other countries, freedom cannot be enjoyed under Article 1 of the Outer Space Treaty. The fourth major principle applicable to the space activities is the principle of common heritage of mankind. Of course, first of all, we have to understand that the province of all mankind and the common heritage of mankind are the two different principles. Even though province of all mankind is a base and the common heritage of mankind is an advancement over the province of all mankind, we should understand that these two principles are quite different. In the common heritage of mankind, which was initially proposed in the Law of the Sea, the Malta's ambassador to the United Nations, Arvid Pardo, he basically proposed it for the regime governing the deep seabed and subsoil. This principle has got 5 major elements. CHM has got 5 major elements. One, that it prohibits the appropriation. The private appropriation is prohibited under the common heritage of mankind because it belongs to everyone, common heritage. Second, it speaks about an international management system. We should have an international management system to regulate the use or maybe to supervise the activities on whatever is considered to be the common heritage of mankind. An international management system has to be brought in. Third, a mandatory sharing of benefit out of the use of these resources. Unlike the province of all mankind, which speaks about a voluntary sharing, common heritage of mankind speaks about a mandatory sharing of the benefit. Fourth, CHM also incorporates the principle of conserving the resources for the future generation. There is also a requirement of sustainable use, sustainable development. So it should not be over-exploitation of those resources, rather actually using of those resources in a sustained manner. So there is an obligation to preserve it for the future generation. Finally, it also speaks about the peaceful uses of the concerned area which has been declared as the CHM. It should not be used for the military purposes, rather it should be used only for the peaceful purposes. So CHM is definitely a much more advanced regime than the province of all mankind. But unfortunately, common heritage of mankind has not been mentioned in the Outer Space Treaty, rather it is mentioned under Article 11 of the Moon Agreement. It has been mentioned under Article 11 of the Moon Agreement. And I have already mentioned that the Moon Agreement has failed to a great extent in practical terms because it has got a very, very limited ratification. Most of the spacefaring nations are outside the Moon Agreement. So consequently, the principle of common heritage of mankind is not having practical significance in the field of space activities. There are 2 limitations. One is that there is a limited ratification of the Moon Agreement, and another limitation is that Moon Agreement is applicable only to the Moon and other celestial bodies. It is not applicable to the Earth orbit or maybe to the outer space. It's not applicable to the entire outer space. So precisely because of that reason, we can't say that outer space is common heritage of mankind. It's a wrong notion. We can at best say that outer space is province of all mankind and nothing more than that. Next, the 5th fundamental principle governing the outer space is with respect to the jurisdiction and control over the space activities. If you look into Article 8 of the Outer Space Treaty, it says that state of registry shall retain jurisdiction and control over the space objects and the personnel thereof. It says about retaining the jurisdiction over the space objects and the personnel thereof. There are multiple things which we need to keep in mind about this jurisdiction and control. On the one hand, Article 8 is worded in such a way that it is not only mentioning about the right of jurisdiction and control, but also a kind of an obligation of jurisdiction and control. Because the wordings are, shall retain the jurisdiction and control over the space objects and the personnel thereof. Shall retain the jurisdiction and control. So given that factor, it in a way imposes an obligation on the state of registry to retain the jurisdiction over the space objects and the personnel. That's one of the issues. Another significant aspect is that Article 8 provides 2 different jurisdictions. One is about the space object. Shall retain the jurisdiction over the space object. In other words, it's a kind of a quasi-territorial jurisdiction over the space object exercising the jurisdiction by the state of registry. On the other hand, it also speaks about personal jurisdiction. When it says space object and the personal thereof, it does not say personal thereon. Had it been personal thereon, it could have been an extension of only quasi-territorial jurisdiction, but it speaks about personal thereof. The meaning of this is that even if the concerned person goes out of the space object, still the state of registry is going to exercise the jurisdiction over that person. If he is making a spacewalk, or if the person is landing on the moon or entering into another space object, even in those circumstances, the state of registry shall have the jurisdiction over that particular person. So it's a combination of both quasi-territorial and personal jurisdiction, and more importantly, without creating any kind of a hierarchy between the quasi-territorial and the personal jurisdiction. I'll come back to this little later, especially because this creates a problem which I'm going to discuss a little later. Next, the sixth fundamental principle is in terms of the cooperation between the states. Cooperation between the states runs like a golden thread throughout the 5 major space treaties. For example, in the Outer Space Treaty, if you look into Article 1, Article 3, Article 9, all of them generally speak about the cooperation. 10, 11, and 12, they also speak about some specific aspects of the cooperation, like say allowing the access to each other's space objects, allowing actually access to the launch of the space object. All those different kinds of the cooperations have been mentioned under Article 10, 11, and 12. Then the Rescue Agreement 1968, wherein the astronauts or the personnel need to be rescued. That is also based on the cooperation between the states. It is a launching state and the state of unintended landing or emergency landing. Both of them need to cooperate in terms of the rescue, in terms of the return, etc., etc. Liability Convention 1972 also banks on the cooperation. Despite it's a matter of liability of the concerned launching state, despite that, it speaks about the cooperation between the launching state and victim state in terms of settling the compensation. Registration Convention 1975 requires the cooperation of the state for registration. Similarly, Moon Agreement also has different provisions in terms of cooperation on the moon and of the celestial body. So therefore, it runs like a golden thread throughout the 5 major space treaties. But unfortunately, most of these provisions do not provide the specific aspects of the cooperation. What shall be the obligation of the states with respect to the cooperation? They have not been spelled out. So consequently, the cooperation between the states has got certain problems in the international space too. Finally, the last fundamental principle is the principle of astronauts as envoys of the mankind. Article 5 of the Outer Space Treaty declares the astronauts as envoys of the mankind. They are not just the representatives of the respective state to which they belong, they are also the representatives of the whole world. They are the representatives of the whole world. Because presumption is that these people who go to the outer space are going to carry on the activities for the common benefit. They should all carry on the activities for the common benefit. So precisely because of that reason, astronauts are having the elevated status of being the representatives of the entire world rather than just being the representatives of their respective states. And by virtue of this elevated status, astronauts also enjoy the privilege of protection during the emergency landing. The second agreement, the 1968, the Rescue Agreement, it is entirely based on the principle that the astronauts are the representatives of the whole mankind and they are not just the representatives of the respective states. So that's why emergency assistance, returning them back to the concerned state, all of them have to be done under the 1968 Rescue Agreement. So these are all the fundamental principles which you can see under the space treaties. Some of them have also got the elevated status of becoming the customary international law. The scholars say that they have attained the status of customary international law, and therefore they are applicable across the globe for all the countries. Moving forward, the next very, very significant aspect is about the responsibility and liability in the space activities. With respect to responsibility and liability, we have 2 provisions under Article 6 and Article 7 of the Outer Space Treaty. Article 6 fixes the state responsibility with respect to every activity, whether it is a governmental activity or a non-governmental activity. Concerned state is responsible. And also it says that every activity has to be licensed and continuously supervised by the respective state. without licensing or continuous supervision, activities should not be permitted by the states concerned. If they permit that, any kind of a damage or any kind of a wrongful act, the concerned state should be responsible for those kind of the consequences. Then we have a separate provision on liability under Article 7 of the Outer Space Treaty, which says that the launching state shall be liable to pay the compensation for the victim state in case of any accident. It speaks about the liability of the launching state. And the definition of the launching state includes 4 different categories of the states. They are: 1, the state which actually launches the satellite; 2nd, the state which procures the launch of the satellite. Like say, one state is owning the satellite and it is launching in the facility of some other country. It is taking the assistance of another country to launch the satellite. So the farmer country is basically procuring the launch of the satellite. That's also a launching state. 3rd category is the state whose territory has been used for the purpose of the launching of the satellite. And finally, the state whose facility has been used, the launch facility, which has been used for the purpose of the launching. All these 4 different categories of the states do come within the ambit of the definition of the launching state. So whenever we refer to launching state, we are having multiple, there is a possibility of multiple states being the launching states, because 4 different categories of the state: one which launches, one which procures the launching, one whose territory has been used, and one whose facility has been used for the purpose of the launch. All of them do come within the ambit of the definition of the launching state. So launching state is liable to compensate the victim state under Article 7 of the Outer Space Treaty. Please keep in mind, if I have to relate back this to the yesterday's discussion on the aviation law, we have discussed that under aviation law, liability is that of the individuals. We have the carrier's liability, we have the operator's liability, we have the product liability in the aviation law. And aviation law does not say directly about the state liability. But whereas if you look into the space law speaks about the liability of the launching state, and it does not mention anything about the private player's liability. Of course, one of the major reasons is that during 1960s and 1970s, when these space treaties were entered, the space activities were confined only to the states. There was no private player. So precisely because of that reason, all these conventions were actually modeled in such a way that they can regulate the state-oriented space activities rather than the private sector-oriented space activities. So the liability norm is entirely different under the space law and the aviation law. Even for that matter, registration and other aspects are also different. That's why aviation law and space law are entirely 2 different disciplines, and they are not interlinked with each other. Right. Continuing from Article 7 of the Outer Space Treaty, let me tell you that Article 7 has been supplemented by a separate convention in the form of the Liability Convention 1972. The Liability Convention 1972 tries to supplement Article 7, and it provides for 2 different kinds of liability. One is absolute liability, another one is fault-based liability. With respect to any damage caused on the surface of the Earth or to the aircraft in flight by any country's space object, the launching state shall be absolutely liable to pay the compensation. But on the contrary, if at all there is a collision between 2 or more space objects, maybe in the airspace or maybe in the outer space, it might be in the airspace or it might be in the outer space. In both the circumstances, liability is on the basis of the fault. Whichever state is at fault, that state shall be liable to pay the compensation to the other state. That's how Article 2 and Article 3 of the Liability Convention speak about the absolute liability and fault-based liability respectively. Then if you look into Article 4 and Article 5 of the Liability Convention, they also speak about joint and several liability in 2 circumstances. Article 4 is on a circumstance wherein there is a collision between 2 or more space objects and the damage is caused to the third state. 2 or more space objects of different countries, right? Damage is caused to the third state. In that circumstances, all those launching states should be jointly and severally liable to the victim state. Under Article 5, in a circumstance wherein there is a satellite which has been jointly launched by multiple states come within the ambit of the definition of launching state, and that satellite causes damage to another state. In that circumstances, Article 5 again speaks about joint and several liability of all the joint launching states. So that's what is mentioned about the joint and several liability under Article 4 and Article 5 of the Liability Convention. One of the major limitations of the Liability Convention is about the restricted definition of damage. If you look into Article 1A of the Liability Convention, it says that damage includes any kind of a death or personal injury, or maybe damage to the person or property, right? So that's what it basically speaks of under Article 1A. But unfortunately, it's a very, very restricted definition, which has been evidenced in the Cosmos 954 incident. You must have heard about erstwhile Soviet Union satellite Cosmos 954 falling over Canadian territory in 1978. Right, the Cosmos 954 fell over the Canadian territory. One of the major problems was that Cosmos 954 was a nuclear power source the satellite. It had got a nuclear power reactor on board the satellite. And when it fell down, what happened was that it did not fall as a single piece, rather it got fragmented. Of course, when the space object makes an unintended entry into the atmosphere, it breaks up. So it broke up, and then ultimately actually the debris spread in huge area in Canada. And one of the major problems was that it could have resulted in the radiation emission in the course of time. So Canada went ahead with the cleaning up and incurred a huge expenditure. There has been expenditure of around 13 million Canadian dollars, which has been actually spent by Canada for the purpose of this entire operation, which was called as Operation Morning Light, right, wherein they collected the debris and whatever radioactive materials were there, they neutralized that, right? But ultimately, one of the major problems for Canada was to fix the liability under the Liability Convention, because the Liability Convention speaks only about the actual damage, whatever has been caused. It doesn't speak about potential damage. Canada has taken all these measures to ensure that in the future there would not be any radiological contamination. It wanted to prevent that. Therefore, it has taken the precautionary measure in terms of cleanup. But Article 1A of the Liability Convention does not include this within the ambit of the definition. So therefore, it's one of the limitations of the Liability Convention. Apart from the aspect of liability, Liability Convention also speaks about the dispute settlement mechanism. That's a separate mechanism. First of all, it speaks about consultation, and through the diplomatic negotiation, the parties have to settle any issue about the liability. And if at all it fails, then also there is another mechanism for the establishment of something called as Claims Commission. A 3-member body, Claims Commission, has to be established for the settlement of any dispute under the Liability Convention. But again, another limitation is that the decision of the Claims Commission is binding only if the states have agreed in advance, but otherwise it is just recommendatory in nature. So therefore, resorting to the dispute settlement mechanism under the Liability Convention might result in waste of time, and ultimately the decision might not be binding as well. That's a limitation in the Liability Convention. Next, we have the Registration Convention 1975. Registration is absolutely essential for the purpose of identification of the space object. To which country the space object belongs, we need to identify for multiple purposes. Number one, maybe it should be helpful in terms of actually fixation of liability, because the state of registry should always be a launching state. So in order to identify which state is the launching state to fix the liability, registration would be helpful. Then even for return of the astronauts or the personnel, with respect to them, the country need to know to which state the space object belongs. So registration helps in the identification, right? So like that, actually for multiple purposes, registration and identification of the space object is very much essential. Article 2 of the Registration Convention speaks about the registration of the space object in the national registry. The concerned launching state, soon after the launch of the space object, has to register in the national registry. And in a circumstance wherein the multiple states are the launching states, they have to jointly decide which among them is going to register the space object. There can be only one state of registry, not multiple. Article 3 and 4 speak about the international registration. United Nations has to maintain, the United Nations Secretary General maintains actually the international registry, and the information has to be given to the UN Secretary General, and in the international registry, these information would also be included by the UN Secretary General. So therefore, there is a process of dual registration, one in the national registry, other one in the international registry. And in the circumstance of a damage, suppose if a satellite of a country falls over another country, and the other country is not in a position to identify to which state the space object belongs, number one, it can refer to the international registry, right, the UN Secretary General's registry, and find out to which state it belongs. Number two, if it is not possible to identify, maybe because the space object is fragmented to such an extent that it is not possible to identify, then other countries, whoever is having the tracking facility, they should help the victim state to identify the space object. So Article 6 of the Registration Convention speaks about such a kind of a cooperation between the countries. So this is all about the process of registration. Now, having discussed the fundamental aspects of the space law, let me tell you briefly about certain practical problems which we are presently facing in terms of the space activities. First issue in terms of this is about the sovereignty and the property rights. As I told, since the beginning, the understanding was that outer space and celestial bodies belong to everyone. And even the US and USSR, after their achievements, maybe say first the landing of the space object, the USSR lunar space object, which has landed on the moon. Subsequently, the first human landing when Armstrong landed on the moon. Of course, Armstrong implanted a flag, US flag on the moon. The question arose whether USSR or maybe United States is going to claim any kind of a sovereignty over the moon or any other celestial bodies. But neither of them claimed sovereignty. And both of them even declared to the extent that they are not going to claim any sovereignty. So since the beginning, it was quite clear that there is absence of sovereignty in the outer space and celestial bodies, which is also incorporated under Article 2 of the Outer Space Treaty. But unfortunately, there are instances wherein this position of the absence of sovereignty in the outer space has been threatened by certain states. Like in 1976, in a declaration called Bogota Declaration, 8 of the equatorial states, the states which are on the Earth's equator, they claimed sovereignty over the geostationary orbit, which is almost 35,800 kilometers above the Earth's surface. They have claimed sovereignty over that. This is primarily because of the reason that geostationary orbit is one of the most useful Earth orbit resource. Everyone wants to have a slot in the geostationary orbit, right? And placing the satellite therein has its own strategic advantage. So precisely because of that reason, everyone wants to have the slot in the geostationary orbit. So these equatorial states, they claimed sovereignty over the geostationary orbit by arguing that they are above their territory, they have got rights over it, all those different kind of arguments they have brought in. Unfortunately for them, the international community has not accepted these arguments. Fortunately for us, this has been rejected. But one of the major concerns arising out of this is that this is one of the instances of threatening the principle of absence of sovereignty in the outer space. It has been strongly rooted under Article 2. Most scholars argue that it has also become part of customary international law, but instances like the Bogota Declaration have threatened the principle of absence of sovereignty in the outer space. The second aspect here is the claim of property rights. Most of you might have also heard about different people claiming property rights over different celestial bodies. And even some people have started the business of selling the parts of the moon and other celestial bodies. Of course, it's a huge business now. If you go through lunarenbassy.com, one which has been started by a person by name Dennis Ho, he has already sold property on the moon and other celestial bodies to a few million people across the globe. Right? He has his own arguments. One of the major arguments is that Article 2 of the Outer Space Treaty, which speaks about national non-appropriation is not applicable to the individuals. But of course, I've already discussed that this is an absurd argument, and definitely individuals also cannot claim any property rights over the outer space of the celestial bodies. But unfortunately, these kind of claims are increasing. Even some cases have gone to the courts of law, like a person by name Gregory Nimitz. He claimed property rights over an asteroid, and there was a case in the United States. Of course, US court has rejected his claim. Similarly, in 2012, there was another claim done by a Canadian by name Sylvia Langevin, who also basically claimed the property rights over different celestial bodies. But whatever it may be, it's a real concern, and definitely such kind of a development should not be allowed to continue in the course of time. Next aspect of protection of the space environment. Space environment is very fragile. Unlike the Earth's atmosphere, space atmosphere is actually not dense. So consequently, any damage, whatever is caused in the outer space environment, is going to have the long-lasting effect. And you can see that at present, the lower Earth orbit as well as the medium Earth orbit has been completely filled with the space debris. There are a lot of space debris, which is going to threaten our future activities in the outer space itself. We have to penetrate this debris cloud, and we have to place a satellite above this, if at all we have to go above these orbits. Plus, even if you place the satellite above, those satellites would not be able to sense the Earth properly, because all these debris cloud are going to create a kind of actually a shield for sensing the Earth. So therefore, all these are the major problems which are faced in the outer space activities. We have only one major provision regarding the environmental protection in the Outer Space Treaty, that is Article 9 of the Outer Space Treaty. But I should say that it is grossly inadequate, because it says on the one hand there should be prevention of harmful contamination of the outer space. On the other hand, it says that there shall not be any adverse changes in the Earth environment. While carrying on the activities, there should not be harmful contamination of the outer space, and there should not be any adverse changes in the Earth environment. But any lawyer who can apply the common sense can understand that harmful contamination is a narrower term than the adverse changes in the Earth environment. Harmful contamination is narrower. So given that factor, the state's obligation in the outer space regarding the environmental protection is less when compared to that of the Earth environment. Adverse changes is a wider term. So precisely because of that reason, Article 9 is more oriented towards the protection of the Earth environment rather than outer space environment, which is really problematic. Next major issue is about the military activities. Since the beginning of the space activities, the states have thought in terms of carrying on the military activities in outer space. Because we know 1957, when Sputnik entered into the outer space, both US and USSR were heavily involved in the Cold War. Both of them want to outweigh each other. They wanted to have military advantage. The very entry into the outer space took place because they wanted to have a military use of the outer space. They wanted to take some strategic advantage by the space activities. And this was also known to the world community, and the UN General Assembly in the beginning itself established the UN Corpus, as I have already pointed out. And the UN Corpus is United Nations Committee on the Peaceful Uses of the Outer Space. They wanted to make it clear in the beginning itself that the outer space has to be used for peaceful purposes. While continuing this principle, Article 4 of the Outer Space Treaty speaks about demilitarization or de-weaponization of the outer space. But I should say that Article 4 of the Outer Space Treaty, one of the classic examples of the shabbily drafted treaty provision. This is one of the classic examples of a shabbily drafted treaty provision. If 4 has got 2 paragraphs, first part says that there should not be any placing of nuclear weapons or any other kind of weapons of mass destruction in outer space and celestial bodies. It prohibits the placing of nuclear weapons or any other kind of weapons of mass destruction. Unfortunately, it does not prohibit all kind of weapons. Only nuclear weapons and weapons of mass destruction, which itself is a problem. Number 2, in the first part itself, it does not mention testing of the weapons. testing of the weapons in the outer space has not been prohibited under Article 4. It only speaks about a prohibition on placement of the weapon or orbiting of the weapon in the outer space. So therefore, the ASAT testing, the anti-satellite missile testings, they're all going on without any kind of the restriction. Article 4 has failed to regulate the ASAT testing. If you look into the second paragraph, the second paragraph says that moon and other celestial bodies shall be exclusively used for the peaceful purposes. Problem is that, number one, it does not define what exactly is the peaceful purposes. Is it non-military use or is it non-aggressive use? What exactly it is has not been defined, and more importantly, it misses out outer space. It just mentions moon and other celestial bodies should be exclusively used for the peaceful purposes, which is a real problem, because we are more concerned about the outer space which is closer to the earth being used for the military purposes. Unfortunately, the Article 4 mentions only about moon and other celestial bodies to be exclusively used for the peaceful purposes. So these are the major limitations which we can see under Article 4 of the Outer Space Treaty, and therefore several military activities are carried on in the outer space. There are a lot of military satellites, or maybe even the commercial satellites, having the military applications which are existing there in the outer space. Next, another very significant aspect is the intellectual property issue. When I speak about the IP, I would like to point out majorly the patents in the outer space. We have an international space station, which is a collaborative venture of the US, Russia, Japan, and the European Space Agency, Canada, right? So therefore, we have an international space station. We are also having plans for constructing other space stations. Different other plans are going on, and all these are happening for the purpose of the space research. Right? The countries want to carry on the research in the outer space, especially in the pharmaceutical level. The more and more research is expected, since the more pure form of different kind of actually the components can be created in the outer space in the near zero gravity level. Especially there is evidence to the fact that more pure form of a protein crystal can be created in the outer space due to the near zero gravity atmosphere in the outer space. So these stations are primarily for the purpose of carrying on the research in outer space. Once the research is carried on, the immediate question is that what should be the patent law applicable therein? Can these inventions, whatever is carried on in the outer space, be patented? This is very, very crucial, because patent speaks about a monopoly right. The inventor would get a monopoly right for a particular period of the time. But whereas space law, as I have already discussed, speak about the common rights, benefit of everyone. It does not speak about the individual monopoly right. So when outer space or maybe resources available in the celestial bodies are used for the purpose of any invention, can we go for patent? More particularly the product patent. Can we grant the product patent? Right? So that is a debatable issue. Then another important aspect which comes up regarding the patents in the outer space is, what if an earthly patent is infringed in outer space? When I say this, I mean that a particular patent has been registered in a particular country, and this patent has been infringed in the outer space by an inventor. In that circumstances, what law we are going to apply and who will be having the jurisdiction to try this? This is very crucial, because we don't have an international patent law. Patent law are domestic in nature. Each country is having different patent law, and the aspect of jurisdiction and applicable law becomes very, very crucial if there is an infringement of an earthly patent in the outer space. Jurisdiction, let me revert back to Article 8, which I've already discussed, wherein I told that the state of registry is not only having a right, but also is having an obligation to retain jurisdiction on the space objects and the personnel thereof. Combination of two, quasi-territorial and personal jurisdiction. Let me give you a hypothetical example. Say, for example, a particular astronaut has been sent from India. India has registered the space object. In the Indian registered space object, an astronaut has been sent to the International Space Station. And this astronaut goes to the Canadian module of International Space Station. And if you look into the status, each of these modules, whatever has been contributed by the states to the International Space Station, they have been registered by the respective states. Canadian module by Canada, Japanese module by Japan, Russian by Russia, like that they have registered it. So this astronaut enters into the Canadian module and he infringes an earthly invention in the Canadian module. Now the question is, who is going to exercise the jurisdiction to try this infringement? Should it be India or should it be Canada? Going by Article 8, both the countries, because India would be having the personal jurisdiction. This person has actually entered into the Canadian module through the Indian space object. So therefore, India has a personal jurisdiction. On the contrary, Canada is having a quasi-territorial jurisdiction over its module. So precisely because of that reason, there would be a conflicting jurisdiction. We will be having no solution for this since Article 8 does not provide any hierarchy. Similarly, we also have problem with respect to the applicable law, which country's law has to be made applicable for dealing with the infringement. That's also very much debatable. So therefore, issues of patents in the outer space is something very, very crucial. Probably it is going to be one of the major issues in the course of time. Next, about the financing of the private space activities. Of course, I have already discussed this in yesterday's session in the aviation financing. I'm not going to discuss again. Please keep in mind, space activities would involve huge investments, and the financiers would not invest in the space activities unless and until they are sure about their returns. Unless and until they are getting back their money, they will not invest. So therefore, UNIDROIT, as I told in the yesterday's session, has tried to come up with an international norm regarding the financing, even about the space financing. But unfortunately, the UNIDROIT's system regarding the space financing has not come into existence at present. Only on the aviation financing it has come into existence, but on the space financing it has not come into existence. Therefore, currently we are dependent on the respective municipal laws with respect to the financing, respective municipal laws, and therefore the problems are faced by the financiers unless and until they are very clear about the return. They are not investing in the space activities. Finally, the last thing which I would like to point out is about the national space laws. Along with the international treaties or international space law, there is a need for the national space law as well at present. This is because, as I have already pointed out, international treaties mention only about the regulation of the state-oriented space activities. They were not entered at the time when the private players have joined into the space activities. So therefore, currently with the development of the private space activities, in order to regulate them, national space laws are mandatory. I have already pointed out Article 6 of the Outer Space Treaty. States cannot allow the activities, whether it is the governmental or private activities, unless and until there is a license and authorization. For licensing and also supervision, law need to be developed. Any country which would like to actually allow the private player need to develop a law properly for the licensing, supervision, and even for fixation of liability, etc., etc. Right? So there is only state liability, there is no private player's liability. So in order to ensure that the liability is cushioned by the private player, maybe through their private liability or through the insurance, for all these purposes, national space legislation is a must. If you look at the global level, there are only a handful of the states which have actually developed their national space legislation. Very few countries. And amongst them, we can find two approaches. One is a kind of a completely commerce-oriented approach. Another one is a somewhat balanced approach. When I say completely commerce-oriented approach, I say a kind of an approach wherein those countries are promoting only the commercial activities without respecting the international fundamental space treaty principles. The fundamental principles, the common rights principles, they are not trying to respect them. Instead, they are trying to commercialize as much as possible. And we can find this trend primarily in the United States, and even for that matter, Australian legislation. They are all oriented towards the commercial interests of the private players. United States has even gone to the extent of conferring the private rights over the resources, asteroid resources. In 2015 Space Act, they have mentioned that even the private players can go to the asteroids, they can mine the resources, they can claim the property rights over those resources. They are rejecting the argument of the rest communities. They are rejecting the argument of province of all mankind, right? So they are putting forward their stake over these celestial resources. 2020, the last year, United States has also come up with what is called as Artemis Accord. Artemis Accord for the purpose of exploiting the resources on the moon, and they are seeking the cooperation from different countries for the exploitation of these resources. Luxembourg has also followed the US pursuit. In 2017, they have also passed the Space Act, wherein they have agreed to confer the private property rights to the individuals or the companies exploiting the resources in the asteroid. So therefore, these kind of developments are taking place, which are completely against the common rights principles which are developed in the 20th century. And I think it's unhealthy. We can see that other countries, the Middle East countries like UAE, and then other Middle East countries are also entering into similar kind of the legislation. They're also trying to promote the privatization by compromising the principle of the common good. So that's the commerce-oriented approach. On the other hand, we have somewhat balanced approach, wherein we can find that international space treaty principles are incorporated along with the promotion of the commercial interest. And I should say that Russian legislation and the UK legislation, to a certain extent, try to incorporate these principles. I'm not saying that they're very well balanced. I'm not saying that actually they're the classic examples of the national space laws. But what I'm saying is that they're trying to incorporate certain fundamental space law treaty principles along with the promotion of the commercial interest. International Law Association has come up with a model law in 2013, because national space legislations in different countries are coming up with the differences. There is no harmonization. Different countries are taking different approaches. So in order to prevent the bifurcation of the laws, International Law Association has come up with a model law wherein some fundamental principles are mentioned therein. But then again, unfortunately, it is not adequate enough. In one of my papers, which has been published in the Journal of Space Law, University of Mississippi, anyone who is interested can go through that. It's available in Hein online. I have basically pointed out what are the major lacuna in the model law, and also what are the problems in the provisions incorporated therein. All those things are discussed in detail, so anyone who is interested can go through it. As far as the Asian response is concerned, in Asia, there is only one country which has got a detailed legislation, that is South Korea. Only Republic of Korea has got a detailed laws regarding the space activities. No other Asian country has got a detailed national space legislation. India, for that matter, is attempting to come up with the legislation since the beginning of this century itself, but unfortunately that has not happened till today. We could not actually have a national legislation despite the efforts which are taking place at different level. And even in 2017, a draft the space activities bill has been actually prepared, and it has been open for the public comment. But unfortunately, there are a lot of actually loopholes or the gaps in the draft. So precisely because of that reason, it has not come into existence even till today. We are still in search of the national space legislation. And you must have heard during this COVID time last year, Prime Minister Modi has already come up with the plan for privatization of the space activities. IN Space as an agency is going to be established for the purpose of promoting more and more private space activities in India. But all these things cannot happen unless and until we have a proper legislation which basically deals with the issue of liability, issue of insurance, right? So all these things are crucial for the purpose of the carrying on the space activities and also financing the space activities. So I should say that India should quickly move towards adopting the national space legislation, and probably once the national space legislation is adopted, there will be more and more private space activities, more and more litigations, and more scope for the lawyers. That's all. Thank you so much.
Thank you, Mr. Bhat. And as usual, you have taken us way back from 1950s till the latest as to how the conventions, how they could have to go across, and then how we have to also think about the insurance and liabilities, etc. As I earlier shared, this is a new topic wherein people are actually trying to learn. People would also include students and lawyers itself. because rightly said, and that is why there are very few universities and colleges wherein the subject of space aviation and aviation is being taken up. But to understand from a speaker who can actually take us through the entire journey is always a pleasant experience. We don't have any question of the thing, but yes, I'd seen on the Facebook we had. Kindly unmute yourself. This is by Pankaj. It says, Pankaj, misuse of chemical weapons against any other countries as virus used against as also the control of this, as also under this control of space law. While you are using the chemical weapons,
I don't hear you. Can you repeat it? Can you repeat?
If any country uses chemical weapons against any other country as virus, can it be controlled under the space law?
Okay. That might be possible under Article 4 because it covers the nuclear weapons or any other kind of weapons of mass destruction. So biological and chemical weapons have been already qualified as the weapon of mass destruction. So therefore, it should come within the ambit of it.
And second question is, are there any guidelines regarding use of outer space for communication purposes?
Yes, absolutely. We have the principle on direct television broadcasting as well as actually principles on remote sensing. Both of them actually have certain aspects regarding the communication, right? So it's primarily with respect to the communication, but it's only the set of principles. They are not the treaties. So precisely because of that reason, the binding effect of these set of principles is really debatable. That's why the states are having their own separate norms regarding the communication.
This is by Iftikhar Ahmed. Do TV satellite channels come under the purview of space law or any other law?
As I said, the direct television broadcasting comes within the ambit of the set of principles. Only the direct television broadcasting, the principles on the direct television broadcasting. But ultimately, actually, see, for regulation, the domestic level, it's all the domestic municipal legislation which would be governing, not the international law per se.
Yeah. So, I've taken the questions by Sarita also from the segment. Just hold on. Before we part for the day, I have to announce the tomorrow's session. Yeah. Thank you to all those participants who have been watching us live on the Facebook and the YouTube, as well as on this platform. As we all know that the topic is fascinating, but at the same time, we can say that we are taking the baby steps. But as Armstrong said in the 1969, that this step of mine is a huge step in the mankind. So we all think that Mr. Bhat is going to take us into a different league and different thought processes. And for students of law, they will also understand what are the career avenues. Before we part, I'll ask Mr. Bhat that how are the careers growing in India and abroad in space law?
I think I've addressed this in the beginning itself, but anyhow, let me actually just repeat it.
Because sometimes the students, the participant enter into the late because they know the question answer session will come.
Yeah, I can understand. Not a problem. I will repeat it. Not an issue actually. I told in the beginning itself that sitting in India, we might not be able to appreciate actually how much of the development has taken place in space law. This is because in India, the private space activities, actually, I mean, of course, some incidental activities have started, but the major private space activities have not started in India. We can find that in countries like the United States, European countries, or even in Australia for that matter, a lot of private space activities are going on. And given that factor, each of these kind of activities would be involving actually a lot of legal issues. Starting from maybe the contracts, then the financing, financing. So what is the fails to pay back the money to the creditor? How exactly it has to be settled? Then we have the issues like patents or even issues like confidential information. It's a high-end technology. So employees of one company going to another company and sharing the confidential details, all these kind of issues have cropped up in the space activities. And apart from that, liability is definitely one of the issues which would always crop up with respect to the space activity. And therefore, there is a lot of scope for practice. Unfortunately, in India, since the private space activities are yet to kickstart, we don't understand much. But in the western part of the world, there are many law firms which are practicing predominantly in the field of space law. So therefore, it's in my lifetime. So it is like that actually in the space activity. there is a lot of scope no hesitation in repeating the fact that space law is going to be the law of this particular century.
Yeah. Before we part for the day,
So, I think,
before we part for the day, tomorrow's session is money suits under CPC, summary suits under Order 37 CPC, and the Limitation Act 1963. This is by Mr. Vishwanath V. Angdi, a former principal city and session judge, Karnataka, and as he's also an arbitrator. And tomorrow we are knowledge partner with KLE College from Karnataka and in Bangalore. So do stay connected with us at 4:30 p.m. And thank you, Mr. Bhat, for giving us an insightful session. And we were actually in a different space while you were taking us to the entire unlocking of the space law, we can say the bird eye view. So do stay connected with us for all the webinars. And Mr. Bhat, we would love to have another session with you on a different topic and at a different point of time. Thank you. And kindly, if you can you can unmute yourself.
Yep. Yeah. Thank you so much.
Thank you. Thank you.